School of Management, but I recently finished a stint for about a year and a half as chief economist in the Antitrust Division at the Department of Justice in the United States. The reason that the Department of Justice Antitrust Division is interested in standards is that they pose a sort of an interesting competition problem. Normally, we don't think that competitors getting together and agreeing on things is good for the consumer. But in the case of standard setting, that might not be true. It might be that consumers are going to benefit a great deal for example, the establishment of Wi-Fi as a standard, so that when they buy their laptop computer and take it to a coffee shop, the Wi-Fi that's working in the coffee shop works on their laptop. So a widely disseminated standard like that can be really good for consumers. So if firms want to get together in a standard setting organization and set up something like that, you might want to encourage that because it's helpful for innovation. Now, the trouble is that you also have to take into account the fact that these are competitors, and you want to limit what standard setting organizations can talk about and so on. So there's a well-established both economic literature and policy literature on that problem. Standard essential patents are the patents that go into one of these standards. We were talking about Wi-Fi before, so you could imagine once the Wi-Fi standard has been set, it relies on some intellectual property that's owned by some of the firms. And typically a standard setting organization will say to these firms, if you want your technology included, you have to promise to license it to users on what are called fair, reasonable, and non-discriminatory terms, FRAND. And that basically means a very low price. And the reason that you want that promise is that if you don't extract that promise up front, let's say the standard becomes successful and popular. Everybody adopts it. Coffee shops invest in routers. Firms invest in factories to make the chips and so forth. And then the owner of the intellectual property says, all right, now that the standard is very popular, I'd like to charge a very high price for my intellectual property. At that point, everybody's locked in. The cost of switching to some other technology is really high, and so they're just going to pay the high price. And foreseeing that, maybe they don't want to invest in the standard, maybe firms and consumers are hesitant to develop the standard because they think, well, I'll just do this, I'll invest, and then later my profits will be taken away by the people whose intellectual property is in this standard. So that's a very bad situation, and to forestall that situation and make sure the standard's successful, you get everybody participating to say, look, I won't do that. I won't expropriate the rents after the fact. I promise to charge a very low rate. The problem is that the SSO, the promise is fair and reasonable and non-discriminatory. It's not 0.02% of something. So there's, of course, then lots of ex post disagreements about what fair, reasonable, and non-discriminatory actually means. And this conference is designed to talk about that and some of the economics behind that, the law behind that, and the policy implications. So it should be very interesting.
Thank you very much. My name is Stuart Graham. I'm at the business school at Georgia Tech presently, but for the last 3 years, prior to March of this year, I served as the first chief economist of the U.S. Patent and Trademark Office. Today, I've been chairing the panel that we had here at the conference, the panel on corporate views of issues in standards essential patents, and it was a lively debate. We had a diversity of opinions, diversity of technology companies. So it's interesting. A lot of the members of the panel were reacting to various groundbreaking changes that are happening currently in the legal treatment. What we've seen of late is more involvement by the competition agencies on these issues, particularly on issues related to the definition of the RAND commitment, on whether the RAND commitment runs with the patent when the patent is transferred, on whether and to what extent the RAND commitment precludes the availability of injunctions or exclusion orders in the international trade arena. And also several patent-related cases, particularly those that are happening in Europe and the United States right now, court cases. And what we saw today was, I believe, a general level of consensus among people as to what the chief issues are and maybe less consensus about how we might get to solutions of them. But by and large, I think the view of from the trenches is largely that the system of RAND in standard development organizations is by and large working. That the problems may be somewhat overstated. Although there was clearly opinion from some on the panel that there were significant problems that needed to be addressed by someone. Now, whether that's the standard development organizations themselves, whether that's courts, whether that's competition agencies, was not directly answered, but nevertheless, I think that it is true that there was a lot of consensus here. The general consensus from the corporations is that the standards development process is an engine for innovation, and that it's pretty clear that we as economists and the competition agencies agree with that standpoint. The general consensus is that this engine and the RAND system of licensing that supports the deployment of intellectual property into standards is working adequately and supports innovation. Of course, what some of the economists in the room pointed out was that what we don't observe is the counterfactual. What we don't observe is how much innovation we would have if some of the issues that some of the corporate people recognize are pregnant in the environment were solved to a better degree than what they are.
I'm Keith Maskus. I'm a professor of economics at the University of Colorado, and I am the chair of a National Academy of Sciences committee looking into issues of intellectual property management in standard setting organizations, particularly in the ICT area. Right, so the original motivation for the study was to sort of look at what's going on the international community in terms of SSO procedures around the world, what's happening in terms of emerging economies, China, Brazil, India, but also, of course, because these issues cross borders. If you have a standard in one country and you want to sell your product in another country, there may be some exclusion orders coming, depending upon how the courts deal with patent infringement. Well, then it becomes an important question for innovation, for technology and growth. So we're really trying to look at how SSOs, their rules, their processes and practices manage expectations about the use of intellectual property and licensing of intellectual property. So particularly in the ICT area, when we talk about microelectronics like smartphones, those embody a great many patents, some of which are necessary for the implementation of a standard that allows interoperability and talking